I am Dave Hanson. I serve as chairperson of the Master's Level Psychology Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call. Danielle Johnson.
Present.
Shelley Duncan.
Present.
Susan Monaghan.
Present.
Iris Paul.
Present.
Thomas Pletcher. Present. Joshua Tanway. Present. I note the following staff members are also present: David Fye, Leslie Allen, Ashley Van Buskirk, Assistant Attorneys General Janet Arndt and Laney Barr, who are assigned to the board as General Counsel, are also present. Next, Leslie Allen will read a message concerning this meeting being held remotely.
This is Leslie Allen, Assistant Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meetings Act, KOMA, does not require the advisory committee to provide public comment to answer questions from individuals. There will be no public comment on the meeting today to ensure adequate time for the items currently on the advisory committee's agenda. Because we are conducting the public meeting remotely by conference call and other teleconference by conference call, as due to technical difficulties, we are unable to use the YouTube channel. I state for the record the following information. Because the emergency declaration that was issued for the COVID-19 pandemic has been extended to March 31st, 2021, the meeting is being conducted remotely to comply with health and safety concerns, as the board's conference room cannot accommodate social distancing for everyone in attendance. However, access to this meeting is being conducted by a medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call. While the meeting is conducted remotely, the requirements of the KOMA are not suspended. As such, we will be conducting this meeting pursuant to the KOMA and KR 16-20-1 concerning compliance with the KOMA during the existing emergency disaster declaration. 1. On February 8, 2021, we sent notice of the advisory committee meeting to the individuals who have requested notice of the advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting materials was posted to the board's website on the day of the meeting. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call that allows the public to attend this meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240. Each member of the advisory committee, staff, or presenter shall state the person's name and title each time the person speaks or votes. Each participant to this meeting shall ensure microphones, phones, or other electronic devices are on mute when the participant is not speaking. Each motion will be clearly stated before the advisory committee votes, and each advisory committee member will vote when their name is called. The chairperson will announce the result of the final vote. The advisory committee lacks authority to delegate a member of the committee or staff to sign any binding document on behalf of the board. Thus, no such statement or motion will be made. A recording of the meeting will be posted to the board's website. The advisory committee has the following items listed on its agenda: introduction by chair, roll call, information on remote meetings, additions to the agenda, approval of the agenda, review of the minutes, advisory committee training, executive session, executive director's report, old business, new business, additional agenda items, and adjournment. The advisory committee agendas includes an executive session. If the advisory committee elects to go into executive session, the advisory committee will follow this process. 1. First, the advisory committee must be in an open session before going into an executive session. 2. Then an advisory committee member must make a motion to recess for an executive session that is seconded by another advisory committee member. Each advisory committee member will then vote. A majority of the advisory committee must vote in favor of the motion to exercise the executive session. The chair will announce the results of the votes. The motion must contain a statement of justification for closure and the subject to be discussed pursuant to KSA 75-4319B as in boy, and the time and place the open meeting will resume. 3. If a motion for executive session passes, the conference call will be placed on hold. Attendees may stay on the call or return to the conference call number at the expiration of the executive session to attend the remainder of the meeting. 4. The public will be excluded from the executive session portion of the meeting, as the executive session will be conducted by electronic means that is not available to the public. When the board members return to the conference call, the open meeting will resume through the conference call. The complete motion for an executive session will be recorded in the minutes.
The meeting is now called to order, and the advisory committee will begin its discussion on item 4 on our agenda. Are there any additions to the agenda? No. Okay. Hearing none, we'll move ahead. One question, Leslie, given that we had some technical issues, do we need to post the conference call number on the website in case anybody's out there looking for how they might join?
That is on the website currently. We post both ways to view or be at the meeting.
Very good. Thank you. Okay, everybody have an opportunity to review the minutes from the previous meeting.
Yes.
Were there any requests for changes, additions, or alterations to the minutes? Hearing none, we will consider those approved. The next item is a advisory committee training provided by Assistant Attorney General Jan Arndt. Jan?
Hi, good afternoon, everyone. I'm Jan Arndt, I'm Assistant Attorney General. I've been with the Attorney General's office since 2007. Been assigned to the BSRB since 2011. So I've been here working with the board for almost 10 years. It's always something new to learn, as you have so many different professions, but we try to keep on top of it as best we can. Before going to the AG's office, I started out as a prosecutor, was in private practice, then I was a municipal court judge in Wichita, and then for about 9 years I worked with the Court of Appeals as a research and as a research attorney. So that's a little bit of my background. What the board wanted to do was to, typically we try to give training to the boards every year. The board this time thought that perhaps it would be best to also include the advisory committees in here, because a lot of what applies to the board will apply to the advisory committee. Not a lot of it, because you're not doing anything under the Kansas Administrative Procedure Act, but a lot of times you're giving them advice on maybe things they need to consider for their statutes, their regulations, that type of thing. And you do have open meetings and you do create records, so those are some other things we're going to cover. So the first thing we put at the top of the training is that you're a creature of statute. Pretty much every licensing agency is going to be, well, not pretty much, every licensing agency is a creature of statute. That means that the legislature has enacted statutes that will regulate the different types of professions that have been, that are under your purview. They've also done what's called an enabling act The Enabling Act is where it sets up the board, right? How many people are going to be on the board, what their qualifications have to be, how long their term's going to be, how many terms they can have, what their powers and authorities are. So that's how you're created. And of course, whatever the legislature creates, it can take away. So all they would have to do would be to repeal that Enabling Act and the board is gone. It's the same way with the profession. If they decide that you don't need to regulate a certain profession, they could repeal that professional act, and that would be the end of the licensure. And of course, they can also make amendments to those statutes, which could change things. In addition to the statutes, you also have constitutional limitations, such as due process, equal protection. Those basically mean that the board has to act in a manner that does not result in a disparate or inconsistent treatment of the parties who are similarly situated. You don't adopt different standards for people who have similar situations. And then just a very broad one is that you cannot act arbitrarily, capriciously, or vindictively. An example of the due process and rights and equal protection would be that someone who is you have two people who are similarly situated in their licensure and their education and their experience, but they trip up and make the same mistake. Perhaps it's not getting their CLE done in time, and one person would be given a suspension and the other one a warning letter. So that would be where you're treating people differently. And of course, you never want to act vindictively. You need to treat everyone fairly and impartially and very cordial. Also, the Constitution has rights of privacy, unreasonable search and seizure, freedom of speech, and vagueness. And those are also sort of establish your parameters. The board is fee-funded, which means that the licensees have to pay like application fees, licensure fees, and that goes into your fee fund. However, to spend those fees, you have to get an appropriation from the legislature so that you can use those to pay for the board's expenses. One thing that a lot of boards kind of struggle with is what is the difference between something that's discretionary and something that's mandatory. For that answer, you just look at your statute that's involved. That means that you look to see if it has may. If it has the word may, it's going to be discretionary. That means that you have to look at all the surrounding facts and circumstances for that particular matter and then decide what is the appropriate thing to do. If it says shall, that's mandatory. You don't really have any type of authority not to do it. It's saying that if this, then that. Probably a best example of those two things working in tandem is like on applications. You have your application statute that says the board shall issue a license if the applicant meets all of these qualifications, 1, 2, 3, 4. So if they've met all that, you don't have a reason to deny the license. However, there's also another statute. We often refer to that as a discipline statute because they've also included, in addition to all the discipline on the licensee, they've also included the language that you can refuse to issue a license or deny a license. You may deny a license, and then it has all these reasons. So, they make the qualifications, but then they have something that is discretionary that could refuse them. So one of those examples that we see quite a bit is like someone who has a felony conviction. The board may issue a license to someone with a felony conviction if they've shown rehabilitation. So that's how those two statutes, one is discretionary and one is mandatory, how they work together. Sometimes what is kind of difficult for board members is they want to give discretion, such as to waive something when they don't have the authority, or they want to waive something that's mandatory and they don't have any power to waive it. They want to exercise discretion when there is no discretion, it's mandatory. So oftentimes what they want to do in mandatory is to sort of do like what we refer to as a blanket rule, which means like say that they have authority, they may award attorney's fees, and they want to issue an order that says no one ever is going to get attorney fees. You can't do that because you have discretion. You have to decide whether or not someone would get attorney fees. The general purpose of your licensing acts is to secure the people of Kansas who use your services, that your professionals are competent, trustworthy practitioners, and your decisions are there to protect the public against any unprofessional, unauthorized, or unqualified practitioners. So in essence, you're there to protect the board and not the professional, excuse me. As a board, part of the board, you are there to protect the public. You're not there to protect the licensee or to do what's best for the licensee. Your question should always be, is this going to protect the public? Usually what you're looking for when you're in your licensing acts, you're going to look to see if someone has the qualifications that makes them eligible to get the license, and then the disciplinary process about where perhaps if that license needs to be conditioned, limited, revoked, suspended, or somehow otherwise sanctioned. They do have the authority to place a condition on it, might be supervision, but they also have authority to issue reprimands and to assess fines. If you kind of go back to your government class about the three branches of government, there's the executive, the judicial, and the legislative. And the board has sort of the same type of functions as those for all three. The executive is the administrative function, and that means that's how you carry out the acts that you have to review. So it would be like conducting your open meetings and providing open, and making sure that you're following the Open Records Act and that you conduct the business according to the statutes that are applicable. The Judicial Authority, this is more for board members. Advisory committee members will not use this because this is when they have to make a decision on a particular pending case. So it's usually going to be an application or a discipline matter. Since they're under the Kansas Administrative Procedure Act, this is done by presiding officers, which, according to the definition, is going to be board members. And so for those of you who are not on the board, you don't qualify as a presiding officer. So, but for those who are, as an administrative agency, you use quasi-judicial authority, which means that basically you're acting in a judicial capacity. You're listening to the evidence, you're weighing it, you're determining credibility, you make findings of facts, you determine what the applicable law is, you apply the facts to the law, and then make your conclusions as to whether someone's violated it and a statute, and if so, what the remedy should be. The Kansas Administrative Procedure Act is basically a due process, a statutory due process. You have constitutional due process and statutory due process. If you follow the Kansas Administrative Act, you're probably not going to be getting tripped up on a constitutional due process. So that's why it's important that you follow the Administrative Procedure Act, because then you have uniformity, not just in what you do, but also the way other agencies handle it that are under CAPA. Legislative authority, again, that's like for the legislature, that's enacting statutes. For you, as the board, it's enacting regulations. All regulations have to be pursuant to the Rules and Regulation Filing Act. They have a whole procedure that you have to follow before it can become law. But once you follow all of that, it will be, a regulation will have the force and effect of law. So that's why it's important that everyone have a little bit of familiarity to it so that they understand what the process is and what questions can arise during that process. Okay. In order to fulfill the responsibility that the legislature is giving you, you can make internal policies. A policy would be that you're going to tell your staff on how what you want done. If you go on your website, you have policies. Well, and it kind of informs the statute, but you have policies for like your open records, so how someone can make an open request. You've also got a policy on there about your how, and if someone files a complaint, what happens to that complaint, how it's processed. So that's an example of a policy. And we've discussed a little bit about statutes that are done through the legislature, signed by the governor. Most statutes, as a general rule of thumb, are going to become effective on July 1. The legislature can give them a different date. Sometimes if they believe there's a need to get something on the books quicker than July 1, they will say it becomes law upon publication in the Kansas Register. So once in a while you'll see, something that gets passed fairly quickly to become law, like late in March or perhaps April or May. But it happens, but as a general rule, it's more likely July 1. It can also delay it so that if, say, it's what they're going to do is going to create a lot of work for the agency, they may delay it till January 1 so that the agency has time to gear up to like make applications or whatever they need to do, or to get regulations going so that they will be ready to be effective on that January 1 date, the same time that the act would become, or the statutes would become effective. Regulations are basically to fill in the points that are in the statute. So you can't go outside of your statutory authority. You basically need to get input from the legislature and from the public before it can become law. It's first going, once you have drafted your regulation, the first place right now it's going to go to is to the budget office. The budget office reviews it. They're looking for why you're reviewing it, the impact it's going to have on your licensees and the economy, perhaps on the board or anyone else that may be in there, and to make sure that it doesn't, it's not costly. They're looking for dollar amounts for that. If they think it's too high, they do have the authority not to approve it, and that stops it. But I haven't heard of anything. This came into effect a few years ago, and as of yet, I haven't heard of anything where the cost has kept the regulation from going forward. So they will, the Department of Budget then will stamp what's called an economic impact statement, and they will also stamp in every page on the regulation to show that they have approved it. The next step in the process is going to go to the Department of Administration, and they then review it for style and for grammar and organization. Once they approve it, they're going to stamp every page on the regulation. The next stop is to the Attorney General's office. Attorney General office is going to review the regulation for legality. And so there's a couple things when we're looking for legality that's going to happen. Because we're going to look to see if their authorizing statute is applicable and an implementing statute. The authorizing is basically just, you're looking for language that just says exactly that the board is hereby authorized to enact regulations that will to administer, enforce, and this licensing act. And so that's usually pretty broad regulatory authority, as long as that statute's in the act. The other thing is they may be very specific, and the most common example of that is they say that the board has the authority to issue regulations to designate a fee for a license or application that doesn't exceed these amounts. And then that's why then you have a fee regulation that establishes what the exact fee will be. When you're looking at regulations, you've got to see, is there a need for it? You don't want to just write one because you want to. they're to set a standard as to what people are to do or not to do. So it's not to recite the law. It's not to say to be what we call self-directory, which is telling yourself what to do. You're really looking at, giving guidance to the licensees on what they have to do to comply with the act. Once it's, and I guess the other thing then is to the implementing statute that we look at. That means that the subject matter of the statute and the subject matter in the regulation have to go together. You can't go outside the bounds of your implementing statute. So kind of an example that a predecessor used to give, and I kind of embellish a little bit, is like if the legislature has set up a corral and given you the authority to put thoroughbreds in that and to write regulations to decide what the thoroughbreds have to do to qualify to get in the corral, and tell them what you do this, how you're going to throw them out of the corral. And then what happens is that you've got your corral full of some thoroughbreds, and you go and you see a zebra, and you want to put a zebra in your corral. And it's like, no, because your statutes are about thoroughbreds, you can't put the zebra in there. So, I mean, that's kind of a crazy one, but it's sort of what we're talking about, is that has to go with what the authority has been given to you. A lot of the stuff that follows about the regulations here is more applicable to when you actually start to write one. You can adopt documents by reference, but there's a certain procedure for doing it, because if you just adopt one without putting some qualifications on there, we're going to claim it's an unlawful delegation. Such as, if you want to use some guidelines that the professional association has, then you've got to give a lot of detail about which one it is, such as the publication date, the edition date, so that we know it will be stuck in time. And if the professional association would amend it in the future, then you are the guideline that you have is the one that's in your regulation, not the ones they keep amending. And it will stay that way until the agency goes and amends it to something more current. If there's any changes along this process, usually there will be. They're going to be, perhaps, Department Administration is going to want to make some changes in the way it's worded. It will go back. You make the changes, then it goes back to Department Administration, back to Department. It goes back to the Department of Budget, then to the Administration, and then if those changes are okay, it will come on up to the AG's office. If the AG thinks that some regulation needs further amendment, such as it's vague, it needs more clarity, or then you need more, you need some other statutes. You either need to take statutes out of your history section that you're authorizing and implementing, or to add something, then you have to go back and make those revisions, and again, the whole process starts over again. Once you have everything stamped, you're going to send it to Secretary of State. They then will publish that along with your notice of your public hearing, which has to occur at least 60 days from your notice. And then while you're waiting for that public hearing, you go over to the Joint Committee to see what if they have any questions about it. Normally they do. So you need to be able and ready to respond to their questions they have. Then when you come to the public hearing, people can come and they can give, verbal testimony, or they can provide something in writing. You have to record it, and it's kept permanently. Once they have spoken, then that will go back to the board, and the board, will decide if they want to make any revisions to it based upon the comments they've heard. If so, the process may have to start over with getting all the stamps. You're not required to change it, so it's up to the agency if they want to make that change or not. They decide to go ahead and adopt it, then they have to do a roll call vote, and then that certificate of the vote goes to the Secretary of State, and the Secretary of State will again publish the the regulation in the Kansas Register. If it's a permanent regulation, it's 15 days after publication in the Register. If it's a temporary regulation, the process is the same as going through the Budget Office, the Department of Administration, and the Attorney General's office. Where it changes is you do not go to the Joint Committee. You don't have to have a public hearing on it. Instead, before you can even, once it's all got all the stamps on it, you're going to then go to the State Rules and Regulations Board. They do have the authority to deny it. Unlike the Joint Committee, they do not have the authority to say no to your regulation, but the State Rules and Regulation on a temporary one does. If they approve it, then it's filed with the Secretary of State and published, and then that is when it becomes law. Guidance docket documents, they can describe the board's current approach or interpretation, but they do have to be published. They don't go through the rules and regulation process, but they do have to be published. But they do not have the force and effect of law like a regulation will. Okay. Effectiveness as a board member. The first thing I guess I probably want to point out here is that, as a board member, you're not, this is not the only hat you wear. You're going to have several hats that you wear because you're a licensee, so you're going to have a licensee hat, you're going to have a board member hat or advisory committee hat. If you're an employer, you have that hat. If you belong to a professional association and you are maybe on their board or a committee for them, then you have that hat. The main thing you have to remember is that when you are there on behalf of the board, such as on this advisory committee, the hat you need to wear is the hat for this advisory committee or as a board member. You have to take off all your other hats. So you're not, in a professional association, they're there for the licensees. But as I stated, when you're here for the board or the advisory committee, you're here for the public, what protects the public. And so that's kind of hard sometimes to get get a good grasp of that. An example may be that you have a board member who's very active in the professional association, and they want to come back and make the board do what the professional association says should be done. And that's not the question you need to ask. It's like not what they want us to do, but what is best for the public. So to start out determining what's best for the public, read all of the, you can read the board's enabling acts, which shows how they were created and what their functions are and what their responsibilities are and the authority that they have. The board has several licensing acts, so make sure, as a board member, you're going to have to be familiar with all of them. For the Master's Level Psychologist Advisory Committee, you probably want to really focus in on that act. Reread them until you understand them because there is a lot of detail in them. Make sure you understand the boundaries, especially as a particular statute may apply to whatever you're working on. A regulation also needs to be read for that particular act. The board does not have like one set of regulations that applies to all acts. Rather, each act has their own set of regulations. So again, you'll have to be familiar with those regulations. Probably also need to be kind of aware of the board's policies and internal procedures that they have. One of the things that happens if you get to court is that the court won't want to hear, we've always done it this way. That won't be a defense. So make sure that you always are able to explain, why you did your, arrived at your decision. And if you have any doubt about what your decision is, if there's a legal issue, always make sure that you consult with the Attorney General's office. They do have a general counsel assigned to the board, and then the complaint review committee also has another assistant attorney general assigned to them out of the litigation division. General counsel is out of, we refer to it as LOGIC, which is legal opinions and general counsel. And so they do litigation and we do the general counsel. So, but accordingly, make sure if you've got questions to let us know or let Dave know, and Dave can let us know if we need to have some kind of a consultation. Also, when you're reading those statutes, and your regulations, look over and make sure you understand that something doesn't make sense to you or think it's burdensome. And then it's probably going to be that way to the people who have to follow them. So don't be afraid to say this may need to be changed. Let's think about it. What's the consequences if we change it, and to see if any recommendations need to be done. Discipline is basically just to protect the public and to get the licensees to comply the law. So that's why it needs to be very fair. It can't be vindictive or disproportionate to the severity of the licensee's violations. And sometimes, unfortunately, some people don't get it, or else they don't care, and they will have multiple violations, or over the course of their practice for decades, they may have more, continuous violations. And in that sense, then those are the people that they're going to deserve the harshest if they did, because what they did was so egregious, or they just don't learn and they've got multiple violations and they're just not responding to disciplinary action. Then that's when a revocation may be applicable. So, and again, another note, it's probably in all these, the role of the board is to protect the public. Conflict of interest can arise. It can be really any kind of interest, a financial interest, personal interest. It can be direct or indirect. So you always kind of have to be aware of that. It's something that you're working on, going to create a conflict of interest with what you're doing as a board member. So you kind of have to look for that, to be aware of that, so that if you think you do have a conflict of interest, you can go ahead and see if you think it's necessary to recuse yourself rather than to participate and have that decision challenged. A personal gain is, a financial. So if you deny a license to someone who could be a big competitor to you, then, if you really don't think you can stay neutral, then that would be one. A bias might be that you know the person and you just don't like them. You don't want to see them get licensed, even though they've met every qualification. That would be a bias that you might want to think about not doing that. A personal relationship would be that, your neighbor, I think the example here is that your supervisor is a close friend or a close relative of the licensee, and she's come to you saying she fears something's going to happen to you, and you're afraid that if your vote, if it's not favorable, then there could be retaliation from your supervisor. So again, those are all things to be thinking about. Confidentiality is very important. Any information that is protected while you're in the capacity of a board member or even in an advisory committee, that you need to maintain that confidentiality. It will stay with you not just while you're a board member or an advisory committee member. It will stay throughout until that perhaps that confidentiality would be lifted by a majority of the board or majority of the advisory committee. So that's important to remember. Confidentiality needs to stay that way. There's two ways that usually confidentiality is going to rise. One is executive sessions that occur during an open meeting. The whole purpose of an executive session is to keep that conversation privileged and confidential. And so that it's outside of the public view, because it's not necessary for the public view, like as in getting advice from attorney or personnel matters. Those are typically the two type of executive sessions that a licensing board is going to use. The executive board, not an advisory board, is not going to use an executive session so much, perhaps, except for legal counsel. You don't have anything really to do with the personnel of the board. So if you do go into executive session for legal advice, when you go back into open meeting, if there's action that needs to be taken, you make that after the executive session. If there's none, then you just go back to the regular board meeting. If, however, though, what you shouldn't do is then when you come out of the executive session, start a conversation where it has to do with what was discussed in executive session, because you've just blown the whole purpose of the executive session. Is if you come out in open meeting and start to discuss it or start asking questions about what was said. If you think you need further executive session for general counsel advice, then make another motion to go back into executive session and get that, have those conversations in the executive session and not in the open meeting. And the other type of way that you're going to perhaps get confidential information are deliberation. The board does two kinds of deliberations. It's going to be one, say when they're considering applications, or even if it's a discipline matter, when they are deliberating on what to do with it. Is this person qualified? Well, yeah, they're qualified, but do we need to do something else?
Do them twice a week or 3 times a week.
So that is not anything by statute. That is just something that the law recognizes. It's the same thing when let's say the Kansas Supreme Court meets. You've got multiple justices on there, and they do get together after they've had arguments and they deliberate. But you don't get to know what they said. All you get to know is what's in their decision when it becomes published. So that's sort of the same thing with the board, is that you may have multiple people deliberating on what to do on a particular case, but no one gets to know what that decision is until the order is signed and filed, and then that's when it will become public. And that's all they get to know is what's in the order. You probably may get questions from someone saying, well, why did you do this? I don't understand it. Tell me some more. And it's like, it's the order. All I can tell you is what's in the order. Ex parte communications are basically when you're receiving information or discussing something with someone who is not, someone who they may not be a party to what the case is pending, or else they're a party, but you're having a conversation without the other party there. If you're going to be discussing a matter, you always need to have both parties there. Otherwise, you've had that ex parte. Under ex parte, or under the Kansas Administrative Procedure Act, ex parte communications are prohibited, but if somehow you trip up and you have an ex parte conversation, then what you have to do is to disclose it on the record and let the other people know that you had that ex parte communication, because then that will allow them to decide whether or not they want to ask to have you recused, or you can recuse yourself after having that ex parte communication. And the whole purpose of this is to present, secret information being presented to someone who's going to, ride over, preside in a case. And either one or both of the parties don't know what happened or don't know what's said. And you could be influenced by something that they don't know. So you just kind of also need to be aware of that. And especially once someone finds out you're on the board and they have like an application pending, you may be getting an email or a phone call, but the best thing is, to very politely say, I'm sorry, I can't discuss it. The next thing is your professional activities. As we said, you're probably, most people are a member at least of a professional or trade association for your profession. But that doesn't mean that you can lobby for what that professional association means or would like to have the board do. You can attend professional conferences and social events. There's nothing that prohibits you. However, you need to be very mindful of the Open Meetings Act, which we're going to be going into next, because if there's more than one of you there, or enough, especially if there's enough there that you would make a majority, and you start to discuss the regular business of the board, you've got a COMA violation, and if people see you discussing things, they may make a complaint against you for violating the COMA. So it's just best that if you do go to a social event and there's other board members there, other advisory committee members there, that you don't have those discussions, so that someone may make that complaint. Other type of comment, and right now this is kind of important while the legislature's going on, because the board does have several bills pending they have their own bill pending, as well as there's several other that will impact the board. And as a private citizen, you can always give testimony or make your opinion heard on what you think about those bills. However, in doing so, you need to make crystal clear that you are speaking on your own behalf and that you are not speaking on behalf of the board. The only way you can speak on behalf of the board is if a majority of the board authorizes you to speak on your behalf and to present their viewpoint on it. So that's the only thing, is to make sure that, even if it's not before the legislature, if you're, speaking at the Kiwanis Club or your professional association, make sure that everyone understands that, I'm just, the board hasn't authorized me to speak on behalf of them. This is just my viewpoint. Open Meetings Act, which is referred to as COMA, it's probably one of the things that as the advisory committee and as board member that you need to always keep of most concern. Because if you violate it, there's going to be some penalties for, the more egregious violations at least. It applies basically to legislative administrative bodies and agencies of the state and any subdivision. So consequently, the board is clearly under COMA, and when the board creates these advisory committees and creates the complaint review committee, then those are under COMA. So that's why we need to go over them, because when you have when you meet all the definitions of a COMA, that's when the COMA will kick in, I guess I want to say. It's defined as any gathering or assembly, and you can have it in person or through the use of a telephone or any other means of interactive communication. So that's why it can be in the before the pandemic, they would be in the board's office where people could appear in person. Then we kind of went to Zoom and YouTube, and now, and through telephone conference call, or it could be a combination of those things where some members will appear in person at the board conference room and other people who cannot travel or have conflicts to be there the entire time may appear through a conference call number, or they have also appeared through other video means so that they can be there. It does take a majority of the membership, and that's not the members who happen to be present at the meeting. It's the membership that creates the board. So your board has 12 people, then your majority is going to be 7. If you don't get to the 7, you haven't got a majority, but you also cannot hold the meeting. You can sit there and chit chat if you would like, but you can't have a meeting and do anything. And the whole purpose that you are having the meeting is to discuss the business or affairs of the board. So it's, again, that's why I said it's not there like your social events. You're not going there to discuss the business or affairs of the public, perhaps of the board. But if you start doing that when there is a majority there, that's how you get in trouble with those things. People unfortunately do make complaints like that. Excuse me. A meeting can also occur through informal discussions before or after the meeting or during a recess. So, when you have recesses, make sure that you don't start discussing the business of the board again until everyone is back and you have reconvened the meeting. And it really doesn't matter what you're going to call the meeting. A lot of times people refer to them as a work session or a retreat, but if it meets the definition of a meeting, it's a meeting. You'll hear a lot of people talking about a quorum, and I think some of that is based on old language. It used to be in the open meetings law. It used to be that you conducted a meeting if you had a majority of a quorum present. That was pretty low. So let's say for 12 people, a majority is 7, or a quorum would be 7, and the majority of the quorum would be then 4. So 4 out of 12 people could constitute a meeting. And so they changed that. When they went in, they made several changes, but that was one of them. They took out that language about a quorum, so now it's just a majority. The discussion is just that. It doesn't mean that you vote on anything or that you even take binding action. It's that you're having a discussion about the business of the board. The other thing that this is very important is that if people have requested a notice of the meeting, then you have to give notice of when you're having the meeting and where and when and how they can attend. And so the meetings, you've probably seen there the emails, your board sends out emails to everyone who's requested it, and it has all the meetings on there pretty much. And then from time to time they send out a new one when it changes. So it will have the board members and the advisory committee meetings on there for notice. Notice doesn't have a particular time that you have to give them. It has to be reasonable. So, I mean, if you know a month you're having a meeting, but you wait till the day before, that may not be reasonable. In other instances, a day may be reasonable. Like for right now, we have, like I said, some acts pending before the legislature. If David is working those and keeping up on them, if he thinks, oh, there's something big that happened here, the board has to know this because I have to get back and tell them what the board's position is. He's going to try and schedule a meeting as quickly as possible. And, that may not be that they get, a 2-week notice or anything. They're just going to get what's reasonable under the circumstances. You can, when someone does file a request to get notice, it's good for 1 year, for the fiscal year. So your fiscal year ends June 30th. So usually sometime in the beginning of May, agencies are going to send out a letter to everyone who requested notice and said, hey, if you want to keep your notice, you need to let us know. Otherwise, we're going to take you off of the list. And if they don't respond, you take them off the list. However, if you don't send that out to them, then you cannot take anyone off of the list. There is no procedures that you have to follow during an open meeting. A lot of boards think that they need to follow like Robert's rule, and that's not required. And I always advise don't adopt anything like Robert's rules where it's very, a lot of stuff is in it, and if you don't do it right, you've messed up. But not only that, but it has a lot of constrictions to it, like if you vote a certain way, then you can't bring it back up again. And you don't want that as a board. You want to have the flexibility that if something happens or new information comes to light, then you can go back and revisit that issue. Because your duty is there to protect the public. So if you have some very strict rules that you got to follow, that's not going to help you. I had one board that wanted to follow the Roberts rule, and I said don't do it, but they did it. Later on, then they had a question about Roberts rule and wanted advice, and I said, I'm not under Roberts rule. I'm not the one to give you that. It's not a statute, so you'll have to go to Roberts rule and figure it out. So that's the disadvantage to that. You cannot vote by secret ballot. That means usually what a secret ballot is everyone takes a little piece of paper and they vote yes or no on something. You cannot do that, or even to vote just who you want to for your leadership. Everything has to be open so the public can observe it. There is an old age opinion, but I will advise you not to follow it. It's probably back in the 80s and 90s, and I don't think that the AG's office or district court would say that's good law. It says that, you can put your vote down on a ballot, then it goes to the chair reads, looks at the ballots and then figures out how it went. Then it says you just have to keep those ballots, and someone then and they have to sign it. In addition to putting how they vote, they also have to sign it. Then if someone wants to see how that person voted, they can go into the office, make a core request, and they can look at the ballots to see how people voted. That's not in compliance with COMA. That's not observing them how the board votes. If you make someone and make a core request so they can go look to see the ballot. So I know that AG opinion's out there, but don't rely on it. You are not required to keep minutes under the COMA unless you go into an executive session. And the executive session has to be verbatim. That's why if David thinks we need an executive session, or I think you need an executive session, we're going to draw it up and put it down on paper so it can be read and put in the record, because then it has to be verbatim in the minutes, so that way there's no question about what the motion said. You don't have to have an agenda, but if you do create agenda, then it has to be available to anyone who'd like to have it. Most people think they have a right to speak at an open meeting. They do not. It's just the right to observe it, and they can't become disorderly, or they can be taken out of the meeting. However, most agencies, boards, commissions, they will have a public comment. You can limit the amount of time that people can speak, because otherwise you may not get any business done. But most, you can give public comment, especially if you know that something that you're doing is going to affect a lot of people, and you may want that input before you make any decision. The executive session there's three components. It has to be made, second, and carried. It has to conclude a statement that describes the subject, and it has to be very carefully done, because you don't want to reveal any confidential information. And then you have to include the justification, and that is, justifications are listed in the statute for executive session. And then you have to put in there the time and place that the open meeting is going to convene, and then it has to be, that motion is recorded in the minutes, and it has to be permanently retained by the board. One example, like say if you're going to, one of the justifications could be to describe personnel matters of someone who's not appointed. So let's say it's about someone on the staff. So that would be your justification. And a statement, you don't want, let's say there's issues going on with that person at the office. You don't want to, reveal all that because of their privacy interests. It could be very embarrassing. So it would just be to discuss employee morale or employee evaluation, something like that, so that you're careful not to, reveal too much. And as I said before, that for most licensing boards, the justifications are personnel of non-elected employees and legal consultation. We do get complaints about violations. Violations for open meeting, they're going to center around executive sessions, that one, they were done, or the motion wasn't done properly, or the subject matter wasn't correct. They discussed something else. They had non-board members in the executive session, and you can invite people into your executive session, but they have to have a purpose. They can't just be there to listen or observe. So that's why I say if it's a personnel issue about a staff member, you typically may invite David in there, because he needs to tell you what's going on. So that's why you can invite people in there. And like if you're going to have it for attorney-client, the person that has to go in with you is your attorney. If I were to write up a legal memorandum and then it was sent to you, and so it's a legal memorandum, you can't use an executive session to talk about the legal memorandum without the attorney. So even if the legal memorandum has been done, the attorney still needs to be there to go into executive session to discuss it. Serial communications can be a big one too. Serial communication is when can occur. Usually it's by through emails or a calling tree is what they used to call them. So the calling tree is like David would call up. He'd call board member 1 and talk to him like, "What do you want to do?" And then he'd call board member 2. Well, this is what I'm trying to find out. What's your viewpoints on that? And after he reaches everyone that he knows what they want to do, he would then take action on that or whatever, or just even discussing all that, so that once he reaches that majority, he violates it. And it's the same thing on emails, is that oftentimes you will send out an email to all of the board members, but you have to be very careful. And usually I have a warning on there on my emails: this is for information purposes only. to not violate coma, please don't hit reply all, please don't discuss amongst yourself, wait, if you want to have a board meeting about it, then contact David to set it up. So that's, because if you hit that reply all and make something and enough people start responding, that's how that violation kicks in. Once it reaches majority, you're just having discussions through email rather than at an open meeting. Another biggie is that you forgot to give notice of the meetings. So probably notice of meetings, executive sessions being done correctly, those are the ones that really seem to hit the hot spots. Prosecutions under coma is a civil action, it's not criminal. Any person can bring a coma case, or a county or district attorney, and the attorney general can do that in district court. The county and district attorneys and attorney general have enforcement power, or subpoena power, and private individuals will not. Enforcement of the coma takes precedent over other cases, and so that it can get resolved as early as possible. There's different ways that they can enforce the coma. If someone files it quick enough, they can ask to have the action voided. They can also do an injunction, a mandamus, or a declaratory judgment. But most important for you is probably would be a fine. A fine can be assessed for each violation up to $500 against each member. So the fine is what usually gets people's attention because the state doesn't pay it, the board doesn't pay it, it's the board member or the committee member that did the violation. It's you got to reach into your own pocket. Typically fines aren't going to be that high. I mean, unless it's really egregious and you've done it multiple times, that's pretty unusual. Even just to do fines is kind of unusual because usually what they want is to educate you if it was something that you just weren't aware of and you just kind of accidentally did it. It's more when it can be a learning experience, so they can, like our office, if we're, if a complaint was filed with us, we can do a consent order or issue a finding of a violation and ask and tell you to go do training a little bit more in depth than what this is. So that way we know that you won't, that you'll be more cognizant of it and not have another violation. If our office is doing it and we do a consent order or the finding of a violation, the penalties aren't as great. It's only up to $250 for each one. But you have to sign in an agreement saying that you violated it. Skip over the rest of that. The open meetings, that's kind of the biggies for the open meetings. And there are some resources. I put the link on there to our office. We do give training from time to time on that, and so you can go on that web page and see when we're doing training. We're not doing in-person training anymore. Everything's electronically right now because of COVID. Open Records Act, again, this is to make sure that we're transparent to the public so they know what's going on. What it means, you have a Records Retention Act, which basically means that like state agencies have to keep their records. And they can only dispose of them according to a disposition record that's been approved by the Kansas Historical Society. The record is very broad. It can be electronic, it can be written, and it's anything that they create, that they receive, that they possess, they maintain. So it's pretty much captures it all. So if someone wants to know, hey, I want a record of a motion that the board made, and you've got it written down, then you have to say, okay, here it is, and give it to them. The most problematic are sometimes they want someone's application file. So you have to review all the material that they're requesting and make sure that what's in there can be disclosed, or maybe only parts of it can be disclosed if it needs to be redacted. You can charge the requester the fee to go find the record, to review it and redact it and copy it and mail it out. So depending on the request, it may just be very de minimis and you don't charge them anything, or sometimes it can be several $100s And oftentimes these requests just aren't because they're curious. Sometimes we get them because of attorneys doing this sort of way of doing another method of discovery. Once that comes in, though, the board has 3 days to acknowledge it and to tell them what's going to happen with it. And then once that's in, they need to start working on it and get back with the person to keep them apprised of where their request is at. So this is what's important about COMA. The presumption is that the record's going to be open. And if the agency wants to close it, they have the burden to show there's an exemption from the disclosure. And disclosures can be discretionary and mandatory. A discretionary, usually that comes under, there's a statute in the court that says that these records may be closed. And that's like medical, psychiatric, personnel records, that type of thing. Contracts could be that. So it's discretionary on whether or not you want to close it, but you really need to have super good reason not to do that. I mean, the medical records and things of that are pretty clear because you also have this overlay of HIPAA of not disclosing that information. Another mandatory one, though, also is the Social Security number. So consequently, like on applications, we have a duty to get the Social Security number under law, but under law we also are not supposed to disclose the Social Security number, so it needs to be redacted. You can be fined for releasing Social Security numbers, so that's why that redaction is very important to go through it. So staff reviews it to see what needs to be closed or redacted. If they have questions, then they're going to contact the Attorney General's office to get that assistance. And then when they send it back, if something was not disclosed, we help write the letter to explain why it was not redacted. CORA is like a civil case, just like COMA. It's very much the same thing, where there can be fines assessed for each violation up to $500 for failure to give the information. However, in this instance, it is the board who pays that. It's not the board members. So that's the good news. One thing I want to point out is that, as I said, what your record is very broad. And so I always warn my agencies that, you may be best friends with other people on the board or on your advisory committee, but don't do that. Remember to stay professional when you're talking about board business, because you wouldn't be one of these people that has an email that they wrote with some joke on it showing up on the front page of the Topeka County Journal or the Kansas City Star or the Wichita Eagle, because that's happened in the past. You have to remember that whatever you say can end up going to the public or to a newspaper reporter. So be very cognizant of that. Because, as I said, it includes electronic stuff. So that's how it captures your emails. The other thing I want to point out, because emails are part of the records, that if there is a way to have a state email for board members and so forth, but they're expensive, and some boards have tried them, don't like them. So right now you use your personal email. Under the CORA, the AG does have the right to subpoena records, so if they think that you have something stored on your server, they can get a subpoena to go get that and try and find those emails. That provision was added a few years ago when that's what happened when people were using their private emails to discuss things that should have been in an open meeting. But they kind of, I guess, got lucky, and because they were not state servers, they came off pretty good. The legislature went in and amended that, so it said it didn't matter where that information was stored, as long as it was discussing the board, the business of that agency. So what you can do then to probably avoid getting that subpoena is make sure that if you are sending something about board business that you CC like David on it, and by putting David in there, that then hooks it up to the state server. And if they get a core request, it will pop up. So that's kind of important to remember. Kansas Administrative Procedure Act, as again I said, that's a due process act that has to do with applications for licensure and for discipline. The board members are presiding officers, and other presiding officers are those people who work at the Office of Administrative Hearings. If the board doesn't want to conduct a hearing, they can send it over to the Office of Administrative Hearings, and they will do that. The board can issue final orders. The Office of Administrative Hearing can only issue initial orders. And what that means is that when an initial order is done by the administrative hearing officer, then a party can petition it for review of that initial order, and then the board is considered an agency head, and they have to decide whether or not they want to review it. And if they do review it, then they issue a final order. All final orders then are appealable to the district court. So all of your professions have a CAPA provision, and they do all have CAPA provision. There's only one that's different. So 5 of them are administrative proceedings and disciplinary actions regarding licensure under that has the applicable licensing act shall be conducted in accordance with the Administrative Procedure Act. So that means that when an application or complaint is filed at the very beginning until it's resolved, it's all under CAPA. The only CAPA provision statement that's a little bit different is the Behavior Licensure Act, and it says any action taken under this section which affects any license or imposes any administrative penalty shall be taken only after notice and opportunity for a hearing conducted in accordance with the provisions of the Kansas Administrative Act. So consequently, not everything may be under CAPA in that particular thing, and we need to be very careful. When proceeding, probably you're going to have to get legal advice if you're under the Behavior Analyst Act. The only one of the things about CAPA is, you don't have to give notice to the public. You don't have to give notice to the parties involved unless you're going to have something pending before you. So like when the board is considering probable cause on whether someone violated the act, that's not something that the licensee or the public can view. So they can do that without others watching. And they may want to invite the licensee to come in to hear their side of it. That's up to the Complaint Review Committee. They also don't take a vote like they do out in the open meetings to take action. Rather, they decide what they're going to do, and then there will be a decision reached and an order is typically issued, and it's that order that becomes their action. So the CAPA is really going to be about an identifiable person that has an application pending or a discipline case pending. So it's not about the broad overall things that you do under COMA, which is like approving minutes, deciding, having discussions about approving or amending regulations or delegating authority, budget decisions. Those are your open meeting things. Now, it's possible, like for the Complaint Review Committee, to do both COMA and CAPA. In the past, they have done that, where they may have discussions about maybe something in a statute that they want changed. That would be COMA, but then they close out their COMA meeting and they can go into CAPA proceedings about the particular licensee. Let's see. Once they decide something needs to be done, they can issue a summary, like for a discipline case, they can decide whether or not to issue a summary proceeding order, do a consent agreement, or to have a hearing on it. If they believe that there's an immediate danger to the public, then they have an emergency hearing where they don't have to give the notice an opportunity for a hearing to the licensee, because it's more important to protect the public. Those orders are appealable directly to the district court. They go right from whoever has has the authority to do the emergency proceedings to the district court. If they don't appeal it, then that's it. But once you do your emergency order, you still have to, if you've got more investigation, you're supposed to be finishing that up as promptly as you can and getting it resolved. And so once that's done, then you will have to issue an order that either dissolves the suspension that you gave or makes it longer, or maybe even just revokes the license. People do have the right to have a discovery. The presiding officer is usually what happens. It can be one or more board members, so it doesn't have to be the entire board. They can delegate to certain people to serve as their presiding officers for some matters or for all matters, or they can decide to have it go over to OAH. I really have to give a hats off to those who serve on a complaint review committee, because it's a lot of them. They get hundreds of pages oftentimes that they've got to review for their committees, and have regular meetings and discuss them and come to a decision on what to do. So there's a lot of time. It can be very time consuming. The evidentiary hearing, it's pretty much like what you would think of as going to district court and having a hearing. One party will have the burden of proof to present their evidence. The other party gets to respond and present their evidence. There's arguments back and forth, and then a decision is issued in an order, and it's filed, and the people have the right to decide whether or not to do that. The same thing that we discussed about board members' conduct will apply to presiding officer about ex parte communications and being fair, that type of thing. They can also, again, be disqualified for bias, prejudice, or interest. If someone's line is going to be the licensee fails to appear at the hearing, they can take a default judgment. What that means is that they can say that, you didn't show up, so we're going to deem what was in the summary proceeding order or the petition that you had a hearing, that you wanted a hearing on, to be true and correct. And you've got 15 days in to file a motion to set aside the default. And if you don't file a motion or it's not granted, then that order will become effective. So that's usually not a good idea for someone to go into default, because trying to convince someone to set it aside, it could be difficult unless you have a really good reason, like you were in the hospital or in a wreck on your way to court. Post-hearing matters are usually, once you have your final order, they will also maybe make a motion to reconsider. They think you made a mistake in your findings of facts, or in the law, or you didn't follow the right procedure. Another one would be to make a motion to stay the effectiveness of the decision, and that's usually to give a licensee time so that they can continue to practice while the case is pending. The next step, once that final order's been issued, they file a petition for judicial review. It'll go to a district court. The most common that the two biggest reasons on these are usually going to be that based on the determination of fact, that they're going to say it wasn't supported by the evidence that was substantial when you look at the whole record. The other one is that and I think this is kind of a Hail Mary, is an unreasonable, arbitrary, or capricious. Some of the others would be that you erroneously interpreted the law. They want a different interpretation than what you gave. So when you make your decisions, the main thing you want to look at, be focused on, is how is this decision going to be looked at by a district court? Because you want to make sure that your action, that what you did, is based on the fact, it's based on the law, and the decision you made was very reasonable under those circumstances, so that you can get it upheld. And you want so that you can address everything. The last act is the Kansas Tort Claims Act we're going to cover. This governs when you get sued. You don't have immunity just because you're a board member or advisory committee member, but there is some protection in the Kansas Tort Claims Act. So you have to be operating, it covers employees, but employees are defined to include board members and people, subdivisions of the board. So that's how you get scooped into that. But you have to be acting within your scope. So that means that's why we now circle back up to where we began, which is that you are a creature of statute. Your scope is determined by those statutes. So that's why you always want to be able to point to a statute that you were relying upon to do what you did. And so that's why it's important to know if these statutes are mandatory or discretionary. So what happens if you do get sued? We can't stop anyone from filing a lawsuit. No one can. So if you do get sued, the first thing you want to do is to let the Attorney General's office know within 15 days after being served. That's really important. So if you get served immediately, if you get a hold of Dave or, one of us, and we will tell you then who you need to give it to ask for representation. Because that's what we're there for. If everything was done correctly, we will give you the representation you need in that and file all the pleadings that need to be filed. But you've got to let us know in a very timely manner so that we can do that. We can choose, however, not to defend you if you acted with actual fraud or malice, where you didn't make a timely request for the representation. One other thing I might point out, this is pretty rare, but we can refuse if, say, we gave you legal advice and said, don't do this. This is really big, it's bad, you're going to get sued, it's too big of a risk, don't do it. And you say, no, we want to do it, and you do it, and you get sued. Because then they're going to come and say, why did they do this? What did they come to you? And you said, yeah, and here's what I told them. And they said they're going to do it anyway. Because why would we, and it's not that we're trying to blackmail you into doing what we say, but it's that you were forewarned not to do this, and you elect to do it anyway, then think, well, doesn't matter what I do, I'm going to get this free defense. You could be erroneous in thinking that. So make sure, that you really want to, if we say no, stop and ask questions, and so that we can explain it to you, so that hopefully maybe if you have some misgivings, we can help you with that, so that we do that. Now, on the other hand, if we give you legal advice and it's just wrong, or it's a gray area and we went the wrong way, that's something then, we're not going to knock you for that, because that's, things aren't always as easy as they look. So, in that regard, again, it won't keep you from liability though, but it is a way to mitigate damages. So yeah, you might be liable, but the damages could be could be less, because you can always say, I followed the advice of my attorney. My attorney told me to do this or not to do this. This is why I did it. I didn't have any malice. It wasn't willful, and that will help. So that's just sort of a kind of an outline of it. If you do get, like I said, let us know immediately when you get served and give us a copy of the petition summons. We also ask that you don't sign anything. That's very important, and that you do not say anything, because that could come back to haunt you if you signed something and you didn't understand that it was some kind of a admission. So that's it in a nutshell. Well, it wasn't really a nutshell, it took a little longer. Any questions?
Jan, this is Dave.
Uh-huh.
I have a couple of questions for you.
Okay.
Do the rules of a quorum, are those in effect for advisory committees as well?
Okay, well, the language now, the quorum and majority are usually the same, but not always. But yes, when you're under coma, it's a majority. So it's a majority of the advisory, so the advisory committee. So if the boards put 6 people on your advisory committee, then it's 4 to make a majority.
Thank you. Next question. So you were talking about not adopting the formal kind of Robert's Rules of Order. So does an advisory committee then vote to approve agendas or minutes or make motions in those regard, or just adopt those as formal?
No, you don't really have to have any procedural thing adopted. It's basically opening it up for discussion, someone making a motion, taking a vote on it, and then once you have your vote, then to announce if it's been passed or not. So it's pretty much the way you've been doing them, but it's to make sure that there needs to be an emotion to, I guess, take action, which would be to approve it, to approve an agenda, to approve a minutes, that type of thing, or to approve recommendations to the board, that type of thing.
Thank you. My next question, and you may have just answered that, was around advisory committees, as opposed to taking binding action, make recommendations to the board as a whole. Is that correct?
Yeah, that's pretty typical for advisory committees. They will be, they want to recommend to the board to make changes to a regulation or something. It's not, that's all it is a recommendation. You don't have, as an advisory committee, you can't do anything further other than to recommend it.
Very good. I want to make one other, you often mentioned like contacting David, and I want to make sure that everybody's clear that in that regard you were referring to David Fye.
Yeah, the executive director.
Very good. Anyone else have questions or
Please don't have them call me.
items for clarification? Okay, hearing none. Jan, thank you very much.
You're welcome.
I'd ask for an advisory committee member to make a motion about an executive session.
I'll make a motion for an executive session.
It's already muted.
There's a script there for someone, if they could read that, please.
Yeah, this is Dave Fye. So I sent an email late yesterday which included 2 documents for the executive session and also some standard language to be used for the executive session motion. So if someone could use the executive session motion language, that would be preferred because that should be included in the minutes for this meeting.
David, do you have the motion in front of you?
Yes, I can go ahead and pull that up.
And then if they're having trouble finding theirs, you could just say, is there an advisory committee member who would like to make the following motion, and then read it. And I think your time would probably be 15 minutes.
Okay.
I think we should start doing that.
Sure. And I will go ahead and...
I'm happy if you want me to do it.
Okay, that would be great.
Okay. I'm coming. Okay. I move that the Mastery Level Psychology Advisory Committee recess into executive session for about 15 minutes and reconvene the open meeting at 4:05 p.m. The meeting will be reconvened remotely by conference call at 1-877-278-8686, PIN 327072, and at the link to the board's YouTube channel as stated in the notice of meeting that was sent to individuals who requested notice and published on the board's website, ksbsrb.kansas.gov. The justification is consultation that would be deemed privileged in the attorney-client relationship with the board's legal counsel, Assistant Attorney General Janet Arndt, and Lainey Barnard. The subjects to be discussed in the executive session concern the Kansas Open Meetings Act during the disaster emergency declaration. Board staff were included as the client in the executive session are David Fye and Leslie Allen.
Thank you. We've got a motion. Do I hear a second? This is Tom. I'll second that. Thank you. Any further discussion? All in favor, please say aye.
Aye.
Opposed, same sign. Motion carries.
Okay.
Did Leslie send us an email with that information on attending the executive session?
Yes, so the email that included the executive session motion, that also included the different phone number to use for the executive session. So we would ask members of the board to go ahead and hang up from this line and then dial the different number, so that way none of this is shared over the open meeting. And then, so go ahead and disconnect from this and then dial the executive session phone number and then the PIN that you got over email from me. And then we can go right into the executive session.
Thank you.
Welcome to the Conference Nation conferencing service. Please enter your PIN number to join your conference. Please hold while we place you into your conference.
Okay, the conference line is now active. This is Dave Fye. I'm here with Leslie Allen.
This is Dave Anderson. I'm back. Who's joined, please?
Iris Polly.
Tom Fletcher.
Daniel Johnson.
I have Danielle. Who just joined, please?
This is Jan.
Okay. It looks like we have Danielle, Susan, Iris, Tom, and myself. So we have 5 members. Did someone join?
It's me again. I disconnected and then recalled in, so it's just one of me.
Very good. I think that's everybody.
Great.
Let me take get the sense from the group. Usually we meet from 2 to 4. We're obviously past that time. We have some additional issues on our agenda, so I'm going to ask, do people want to continue with those items, or would you rather carry them over to our next meeting?
I'm available if committee.
I'm available. Yeah.
Okay.
This is Susan. I'm okay.
Okay. Danielle?
Yes, I'm available.
All right. Then we will continue. The next thing on our agenda is the Executive Director's Report.
Great. This is Dave Fye, and I will keep this brief. I apologize for the issues with the technology today. We are currently, as Jan mentioned, in the process of doing a few things differently, and so we have launched the Behavioral Sciences Regulatory Board YouTube channel for the purpose of broadcasting meetings for the public. And we're still ironing out a couple things with that, but I think it's a really nice thing. It'll be a nice way to preserve some of the meetings and have some good way for the public to access the meetings in a more secure way. But I also want to let you know, in terms of our budget, the budget for the agency has been passed out of both the House and the Senate budget committees and the full appropriations committees. So unless there's something that would affect all agencies, that issue's kind of been resolved for this session for us. The other item is there was a bill requested by the Behavioral Sciences Regulatory Board in terms of statutory changes for licensees in different professions. On the House side, that bill is 2208. On the Senate side, the bill number is Senate Bill 238. On the House side, we had a hearing in House Health and Human Services. That committee actually met today and worked the bill, so that was the reason why I had to join you all late in the meeting. But the committee did work the bill. They did make 4 changes to the bill. They removed some language that the committee had, the board had recommended, including to have board-approved supervisors for social workers. They also removed a section that tied to that to establish the fee for those board-approved supervisors at $50. They went ahead and eliminated the 200 hours of direct client contact in the practicum for social workers. And the last change was kind of a substantial change, and I haven't had a chance to go back and look at this, but there is a bill this session, it's 2066, it's a telehealth bill, and or telemedicine bill, and the contents of this telemedicine bill were essentially inserted into the BSRB's bill as an amendment. And so it's basically a new section 2 for the bill, and with that new language being added, the committee went ahead and voted the bill out. So the House Health and Human Services has voted the BSRB's bill out of committee. It's available to be worked on the House floor, so I'll be tracking that bill and trying to answer questions and encouraging members of the legislature to go ahead and work that bill. On the Senate side, the bill has been assigned to the Senate Public Health and Welfare Committee, and that bill has been scheduled for a hearing next week on Wednesday, February 24th at 8:30. The chair of the Senate committee is Senator Hildebrandt, and so I have scheduled a meeting to meet with him the day before the committee to walk through the items in the bill for him and answer any questions. And I'll be submitting proponent testimony on behalf of the board concerning the board's recommendations in the statutes. So just want to let you know where we're at with the bills for the board and with the budget. And in terms of overall operations, we are doing our best to go through and do licenses as quickly as possible. So just want to give you an update on our operations as well. So if you have any questions, please let me know.
Thank you very much, David. Anyone have any questions? Okay, hearing none. Old business. I did want to let the advisory committee know that Barbara Quartz has formally been removed from the advisory committee at the request of the committee by the BSRB chair. Next, Leslie, have we had any follow-up to Dr. Noble's request from our last meeting?
No, I emailed her and told her that you suggested she look at putting it in the 15 extra hours, and she said thank you for all of your help.
Okay, very good.
Dave, did you approve the minutes?
Susan? Yes.
You did in the beginning?
Yes.
Okay. Thank you.
We did not vote on it, but you want us to do that?
No, I don't believe you need to vote on that. I think reaching it by consensus is fine, unless the advisory committee has adopted another way of determining that. So I think that should be fine.
Very good, thank you. Susan, did you want to talk about the interstate compact for occupational licensure?
I followed up with Leo Herman and one other person, and it seems like it's kind of on hold for something at this point, and there's lots of discussion back and forth on what's needed or not needed, and how does the American Psychological Association play into it, because they're working to try and move forward master level psychologists as a health profession. So that's kind of on hold. So I don't have anything new to report on that either, so.
Very good. Under new business, as we had Barbara Quartz removed from our committee, we made numerous attempts to reach out to her unsuccessfully. So I wanted to ask the committee whether you want to stay with our current 7. Do you want to add a new member? What is your will in this regard?
Dave, this is Tom. Are there any gaps that you see in terms of geographical distribution or all the use place of employment as just a general sort of factor of where people might be employed or serving that we don't have representation of?
That's a good question. The only area I can think of is probably kind of the southwest part of the state. Anybody else have any thoughts about that?
This is Danielle. I would agree if there is a space that we need to fill or if there's a geographical diversification that we might want to add, I would say definitely extend the invite.
The other piece that I think is important, and this is Susan, on whether or not it's, are we covering a lot of different areas? Like we have mental health centers, we have somebody from retirement, we have somebody from outpatient type services, things like that, and looking at those pieces besides the geographical area.
And we also have academia. I think we also have academia present, don't we?
Yes.
Yeah. Yeah, Josh represents both private practice and Fort Hays State. Susan, are there any of those areas you think currently that we should be looking at?
I just wanted to make sure that's always something we think about as opposed to only geographical areas. And so I didn't know Josh was into private practice. I knew he was academia, but I didn't know private practice.
Yeah, that's in fact why he had to drop out. He had appointments this afternoon. He works for Clinical Associates, I believe.
I think it would be a plus too if those things intersected, so if it's geographical and meets the needs.
This is Iris, somebody in an inpatient setting or a more a good one too.
For pre-eds and teens, I feel both outpatient pieces and psychiatric treatment.
Okay.
The PRTS.
Okay, good.
All right, well, let's roll that around in our heads and we can bring it up, talk some more at our next meeting.
Dave, this is Iris. Is there a requirement of how many are supposed to be on? Like from the BSRB?
There is, I don't know if it was like 2 other members. It's a low number that they have to be on, but up to 10. Not including the board members.
So we're currently meeting that number?
Yes.
Okay, Okay, this is Tom. Didn't we just say sort of previously that Larry was interested in being on?
That's what he had said, because, yeah, he talked to Max. So maybe
Okay.
Dave or I could email him and ask him if he's still interested, because I believe he's been sent the information, but I'll have to double check.
Okay.
I think I had a previous email exchange with him, so I'll go back and reach out to him again.
Okay.
Okay, just to keep things moving, if he is interested, I would not have any objection to adding him to the advisory committee.
And just for reference for the new members, Larry was the previous chair of this group and BSRB member for this group.
From Western Kansas.
Correct. Susan, I did not share your, go ahead.
Oh, sorry, this is Danielle. Can we have some sort of dashboard or something just to see who all is represented and what, so that in the future we know what gaps that are actually needed to be filled specifically?
Did you guys not receive the committee list with all the members and their place of employment? Is that what you
I'll
mean?
probably have to go back and look, but.
Well, we can send it again. I mean, it's not a big deal. I just didn't know if it had been sent. I'll have Ashley look at it and send it
I'm
out.
not sure.
Okay.
Okay.
That would be great, thank you. Susan, you had sent an email on the Mental Health Access Improvement Act, and I have not forwarded that to people. Do you want to visit briefly about that, and we can decide whether we want to include that on our agenda for an upcoming meeting?
It references conversion therapy for children under the age of 18. And I brought it forward to a number of other people, and there's confusion as to the purpose of the act and the wording of the act. But the piece that I found important for BSRB is that BSRB will be the ones oversighting any of the violations, and it even mentions that we would be oversighting those violations. And the piece that concerns us, or concerns me, is the purpose in regard to kids. We all felt like the purpose was to make sure that therapists would not try to force sexual preference changes or gender changes, and that's what we think the purpose is, but with the wording in this document, we weren't so sure what was meant. And I could foresee working with teenagers who's trying to develop their identity, could a parent misconstrue that and file violations, which then would cause BSRB to have to respond and act. And that's why I brought it to Dave's attention.
So just as a clarification, is that the same act as the Mental Health Access? I thought that one had to do with Medicare reimbursement.
The one I sent included that conversion therapy to you, and that's the one that I'm concerned about for BSRB folks to have to manage.
So Dave, are you aware of the bill that Susan's talking about?
Yes. So this is Dave Fye. I believe there's actually a Senate bill and a House bill that concerns this topic. The House bill is 2207, and I gave sort of a brief summary on it. There was a real quick board meeting, I think it was last week, on a Wednesday morning, and primarily the board discussed some other different bills, but I did briefly cover this bill. But yeah, it is House Bill 2207, and it basically includes language that would prevent conversion therapy to be provided to minors. Yeah, if the members of the advisory committee would like, I can go ahead and send a copy of this bill out after the meeting for members to review.
I just think we need to monitor this bill because it will come down to BSRB having to manage any complaints if it passes.
Yeah, I can
And
say.
I can't imagine that we won't have some parents who may think as therapists, we should be doing conversion therapy and complaining that we didn't do what they wanted us to do with their kids.
Great. So Dave, you'll send that out and people can take a look at that.
Yes, I'll send a copy of that, and at least for the House version 2207, it has not had a hearing yet, or it has not been scheduled for a hearing, and I'll double check the Senate version as well to see where it's at. As of last week, I don't think either bill had been scheduled for a hearing. So.
Very good. Thank you. All right, I would entertain a motion to adjourn. Our next meeting is scheduled for April 8th. That works for everybody?
I believe so.
Yes.
Yes. I move
Okay,
to
I will
adjourn.
make motion to adjourn. And I'll second that.
Very good. Stay warm and stay safe, everyone.
Thank you, you too.
I believe
It's Tom.
Danielle made the motion and Tom seconded.
Thank you so much.
Correct.
Okay. Bye-bye.
Thank you all.
Bye, thank you.
Bye.